Today we are going to be looking at the area of intellectual property law. The law of intellectual property exists above all to promote creativity and innovation. It does this by offering creators or inventors protection as regards the exploitation of the results of their creation or innovation. The extent of the protection offered to investors by the law varies depending on the nature of the actual creation or innovation. For example, a different type of protection is granted depending on whether one is seeking to protect a piece of writing or a newly invented engine part. The extent of the protection granted is governed by the law of intellectual property, which confers different rights for different creations. By relying on intellectual property right, a person can protect their creation. For example, an inventor can protect novel inventions and the methodology behind their manufacture by way of a registered patent. A business can protect its name or logo and the reputation developed thereunder by way of a registered trademark, or more generally, its right can be protected under the law of passing off. A draftsman can protect his designs by relying on the protection given to design rights. Literary and artistic works, computer software, etc., can be protected through the law on copyright. And database rights can be relied on to protect information held in databases. So how does one benefit from this protection? Some intellectual property rights exist or accrue automatically, called soft rights, while for others it is necessary to make an application to the appropriate authorities. These are called hard intellectual property rights. For example, once a design or a literary or artistic work is recorded, a right to prevent the copying of that work exists automatically. Coming under the heading of rights that arise automatically are rights such as copyrights, design rights, and performance rights, i.e. the right to perform the creative musical work of another in public. With all these rights, the rights to exploit the creation rests with the author of the work. However, as we have seen, other rights, such as registered trademarks, patents, and registered designs, need to be applied for and are granted by the relevant authorities. In Europe, such protection can exist at both national and European Union level. Registering a right with the national authorities of a country will only allow protection for the national territory of that country. In the same way, registering the right with a European Union authority will provide the rights holder with protection throughout the Union. To register an application, it is necessary to fill in an application form describing the nature of the right to be protected, accompanied by an appropriate fee. Then, the relevant authority has to process the application and carry out searches to ensure that earlier conflicting right has not already been registered. Then, the right is placed on a register with the applicant described as its legal owner. The advantage of recording ownership of the right on an official register is that the register proves ownership. Thus, in the case of a conflict with a third party that uses the right, the registered owner will not have to go before court to establish ownership. Rather, any action before the court will immediately be centered on punishing the violation of the right. Moreover, should another party claim ownership of the registered right, the burden of proof as regards establishing ownership is placed on the claimant. Now let's take a closer look at the different types of intellectual property rights. As we have seen, there are different types of intellectual property rights, such as patents, trademarks, passing off, copyright, design rights, and database rights. It is perhaps worthwhile to consider the nature of these rights in greater detail. Patents. A patent seeks to protect a newly developed product or invention, or a new method of doing something that represents an improvement on the method previously used. Applying for a patent can be complicated, and in common law countries, the application will normally be made by a patent attorney. In the United Kingdom, to work as a patent attorney, it is necessary to be a qualified lawyer and also to be a member of the Chartered Institute of Patent Attorneys. Upon receipt of the patent, the applicant is the only entity allowed to act within the scope of the patented right. For example, to produce a specific type of product or to use a certain methodology in its creation. For Europe-wide patent protection, it is necessary to apply to the European Patents Office in Munich. Trademarks. A trademark is an indication of the origin of a good or service. In other words, a trademark is used to protect a brand. Businesses frequently invest large sums of money in advertising, design, and quality control in order to develop a brand, and intellectual property law allows them to prevent other businesses from seeking to benefit from that investment. Europe-wide trademark protection can be applied for from the Office for the Harmonization of the Internal Market, the OHIM, or from the national offices in each of the member states. Trademark applications tend to be less complicated than patent applications, and in reality can in some cases be applied for without the necessity of legal assistance. Passing off. In addition to the protection guaranteed under the heading of trademarks, tort law has developed protection under the law of passing off. By bringing an action in passing off, a business can prevent another party from passing off as his own a mark or logo developed by the plaintiff. Passing off is thus a right of action providing protection for unregistered trademarks and may be brought before the courts once a business can establish that 1. Customers recognize or associate a name or logo as denoting the plaintiff's specific business, and 2. Another business, by using the name or logo, or one that is similar, is leading customers to believe that they are connected with the plaintiff's business. Now let's look at the area of copyright. Copyright is relied on to protect the expression of someone's ideas, whether they take literary, artistic, or musical form. A copyright is infringed if a work, or a substantial part thereof, is reproduced without the consent of the copyright owner. Copyright seeks to protect the expression of an idea rather than the idea itself. Thus, if I take a photograph of Charles de Gaulle's house, I will enjoy copyright in the photo, which may not be reproduced and sold without my permission, but I will not be able to prevent another person from taking a picture of the house from exactly the same position. Unlike patents or trademarks, a copyright is conferred automatically once some type of written, artistic, or musical creation occurs. Design rights. Design rights protect the design of three-dimensional objects. As with copyright, design rights occur automatically and do not have to be registered. However, once registered, design rights grant the owner the exclusive right to use the design for the period of time stated in the grant of the right, and create a presumption of ownership. As with patents and trademarks, a registered design right may be sought for a specific country or on a European or international basis. The Patent Office is responsible for registering design rights in the United Kingdom, while the OHIM carries out the same function on a European Union basis. There can be an overlap between trademark protection and design rights, with the major difference being that the former is not limited in time. And finally, let's take a look at database rights. Database rights protect the contents of a database, where the compilation of the database requires the active collection and verification of the data contained therein. Thus, for a database to be capable of registration, it is necessary to show proof of such effort in the compilation of the data. Consequently, it does not suffice to take a list of people from the phone book if one is to successfully obtain database protection over the list. We hope you enjoyed this introduction to the area of intellectual property law.